My name is Anna Goober, and I, along with my co-counsel, Ms. Shana Schulman,
Good afternoon, Your Honor.
will be presenting the opening statement, and Mr. Sahas Chittikayala
Good afternoon, Your Honor.
will be presenting the closing argument, collectively represent the state of Midlands in today's case.
Good afternoon, Your Honor. My name is Joseph Compton, and these are my co-counsel.
My name is Elizabeth Bartlett.
Good afternoon, Your Honor. My name is Bailey Fortenberry.
Ms. Bartlett, Ms. Fortenberry, and I, we represent the defendant, Ms. Dakota Sutcliffe, in today's trial.
Good evening, Your Honor.
Are there any preliminary matters?
Yes, Your Honor, we just have a few items to tender to the bench at this time.
Go ahead.
These include the Midlands Rules of Evidence, relevant Midlands case law, stipulations, special instructions, indictment and bill of particulars, ordered on motions in limine A, jury instructions, discovery responses, and special verdict form. Permission for my co-counsel to tender these to the bench.
Yes. Thank you.
And Your Honor, we just have a few more housekeeping matters to attend to.
Go ahead.
At this time, the state invokes Rule 615, the constructive sequestration of witnesses, barring party representatives. The state does not have a party representative in this case. May we assume that all witnesses have been pre-sworn according to Rule 603?
Yes.
When an objection is sustained, shall we move to strike or consider it stricken?
Ask to strike.
May we assume that all objection arguments are made outside the presence of the jury?
Yes.
Shall we ask permission before using and setting up demonstrative aids and exhibits?
Yes.
May we use the well freely during opening statements and closing argument?
Yes.
Would Your Honor prefer that we direct our statements at the jury, yourself, or both?
Jury.
And as we will be wearing masks throughout the duration of the trial, we just ask that if you have any difficulty hearing us, please let us know so we can repeat our questions.
Sure thing.
And with that, Your Honor, the state is ready to proceed with the opening statement.
Does the defense have any preliminary trial matters?
Yes, Your Honor. First, there's an additional document the defense would like to tender to the bench. This is the Notice of Intent to Offer Character Evidence. May I approach and tender?
You may.
Additionally, Your Honor, if we could direct the court's attention to relevant Midlands case law, specifically the case of State versus Bull. As you are aware, here in Midlands, it is precedent that no defendant is required to provide evidence indicating that they did not commit a crime, nor provide an alternative theory that they did not commit a crime.
Thank you.
Additionally, if we could direct the court's attention to State versus Auburn in the relevant Midlands case law. As you're aware, defendants do not have to speak to police officers in an investigation, and this fact may not be commented on by the state in today's case.
All right, thank you.
Your Honor, at this time, defense is ready to proceed into opening statements.
Great. All right, we will now hear opening statements from each party.
May I proceed?
Go ahead.
Your Honor, opposing counsel, members of the jury, may it please the court. Nothing to lose. One summer night, Jalen Williams started his shift as a firefighter, as he's done countless times before. Although this night would not be like other nights. Just after the clock struck midnight on August 1st, Chuggy's bar was on fire. Jalen Williams went into that building. As the fire spread, with black smoke everywhere, the building began to crumble. Jalen fell through the floorboards and took his last breath. Now you'll hear today, this fire was not an accident. The defendant, Dakota Sutcliffe, was the owner of Chuggy's bar. You'll learn it all started when she took out a $1 million loan to renovate Chuggy's. That's when things took a turn for the worse. The The renovations were delayed, COVID-19 shut down the bar, and then the defendant just stopped making her loan payments. She was losing time, losing business, losing money until she had nothing left to lose, except her bar. Now you'll hear today that just a few days before that fire, she took out a fire insurance policy. That meant that if Chuggies went up in flames, she stood to gain $1.5 million. So, she set Chuggies on fire. That is why we have charged the defendant with aggravated arson. As the prosecution, we hold the burden in today's case. We must prove beyond a reasonable doubt that the defendant knowingly created a fire, and in doing so, put people's lives at risk. Now, we don't have to prove to you that she intended for anyone to get hurt or intended for any of this to happen. All we have to show you is that she knew her actions could lead to a fire so dangerous that someone could get hurt or killed. And we will meet this burden by presenting you with evidence that shows there's only one reasonable explanation. The defendant had nothing to lose. Now we'll show you today she ended up in this situation months before the fire. Nora Khan is a detective with the Midlands Police Department. She'll explain how time and time again she told the bank she just can't make those loan payments. And that amount kept adding up with every passing month. You'll also hear about the defendant's financial struggles from Ms. Skylar DeJean, a former bartender at Chuggies. She'll explain that the defendant asked the employees to take a pay cut before firing most of the staff. On the night of the fire, Ms. DeJean saw the defendant. She'll testify that she saw the defendant walk from Chuggies bar to the fire station. And within minutes of her getting there, it was on fire. Now, once the fire was out, Detective Daniel Weber was on the scene. As an arson investigator, it's his job to look at the damage and figure out how this fire happened. And that's exactly what he will do today. He'll explain to you where this fire started and what caused it, showing you that he found on the walls fire accelerant, meaning this fire was man-made. Now, members of the jury, the defendant had nothing to lose, but the firefighters who went into that building did. And Jalen Williams lost his life because of it. He'll never again get to go home to his family or do the job that he loves. That is why at the end of trial, my co-counsel, Mr. Chinta Kayala, will come before you and ask you to find the only fair and just verdict. Find the defendant guilty. Thank you.
Thanks, Steve. Go ahead. May it please the court, opposing counsel, members of the jury. You don't burn down what you built up. This is Dakota Sutcliffe, a small business owner, a volunteer firefighter, a friend, a woman who gave everything she had to her community, including her dream for a new Chuggies. 101 Bluewood Boulevard, Midland Center. For years, the spot where locals and travelers alike could find solace in the escape from reality that Chuggies offered. But by the summer of 2019, the Chuggies legacy had been dragged through the mud by the owner's legal issues. For a moment, it seemed like Chuggies was no more. The institution that so many called home to was being sold, and due to the recent history, there wasn't an offer in sight.
That was until Dakota Sutcliffe walked into the picture in the fall of 2019 and she bought the bar. Ms. Sutcliffe was determined to restore Chuggy's back to its glory days, but more than that, she had dreams. She had plans for a bigger, brighter Chuggy's, and she was going to make those dreams a reality, not for herself, but for the Midland Center community. Now we're here today because on the early morning of August 1st, 2020, Ms. Sutcliffe's bar was set aflame. 4 firefighters went inside Chuggy's that day in an attempt to save that burning building, and only 3 came out alive. That tragic morning, the Midlands community lost an institution, but more importantly, they lost firefighter Jalen Williams. And today, ladies and gentlemen, the state is attempting to place the blame, not only of the fire, but of the death of Jalen Williams on Dakota Sutcliffe. They'll tell you that Ms. Sutcliffe had nothing to lose. They've created a story to deal with the tragedy that is the loss of Mr. Williams, but members of the jury, that doesn't make it the truth, because you don't burn down what you built up. So here's where the real story begins. The fall of 2019, after Ms. Sutcliffe bought the bar. You're going to hear from Mr. Tobin Johnson today, someone who watched Ms. Sutcliffe's story unfold from the moment it began. Mr. Johnson was an employee at Chuggy's both before and after Dakota took ownership. He'll tell you that he witnessed the change in atmosphere once Dakota took over. He'll tell you that Dakota was a law-abiding business owner, an avid rule follower, that she dedicated her time and money into Chuggy's, and it was a decision that she did not take lightly. Mr. Johnson will then tell you that he was the last person to see Dakota before Chuggy's was engulfed in smoke, and he will tell you that he did not see her ignite that flame. In fact, Mr. Johnson will tell you that Ms. Sutcliffe had plans to continue renovations the very following day. Next, you're going to hear from firefighter Alex Silva, who fought fires right here in Midland Center for nearly a decade. And for 4 of those years, Dakota Sutcliffe fought them right alongside her. Ms. Silva will tell you that Dakota was an exceptional firefighter, that she was dedicated to helping her community, that she went above and beyond her responsibilities every single chance she got. Then, Ms. Silva will tell you that she was the first responder on the scene on August 1st when Chuggy's burnt down. She will walk you through her experience inside that burning building, and she will tell you what happened that night. Finally, Ms. Isabella Saeed will take the stand, and she will put all the pieces of this puzzle together. Ms. Saeed is a forensic investigator who specializes in arson cases. She will walk you through the state's investigation, through Detective Weber's report, and she'll outline the deficiencies in that report. She will tell you that there is insufficient evidence to conclude that the fire at Chuggy's was created intentionally, meaning, members of the jury, that Dakota Sutcliffe could not have set it intentionally. Now, as the jury in today's case, you have no obligation to assume that Ms. Sutcliffe set fire to her bar. In fact, you have the obligation to assume her innocence. And you have this obligation until the state can prove otherwise, and they must prove this to you beyond any reasonable doubt. That's an extremely high burden for the state to satisfy. In fact, it's the highest in our law system. For the state to prove this to you, they must satisfy 4 elements. First, that Dakota Sutcliffe caused a fire at Chuggy's that created a substantial risk of physical harm. Second, that Dakota Sutcliffe committed an act of arson pursuant to the Midlands Penal Code. Third, that Jalen Williams was emergency personnel according to that code. And fourth, that Mr. Williams was acting in the course of fighting or investigating that fire when he passed away. If the state does not prove every one of these 4 elements to you, you must find Dakota Sutcliffe not guilty. Now, at the end of today's trial, my co-counsel, Mr. Joseph Compton, will come before you. He will walk you through the witness testimony, the applicable law, and the evidence that was admitted. He will ask you for the only verdict that is supported by that evidence, and that is to find Dakota Sutcliffe not guilty of aggravated arson. Now, members of the jury, I urge you to listen carefully to the 6 witnesses that come before you today. you will hear that not one of them can tell you that they saw Miss Sutcliffe set fire to her bar. Because at the end of the day, ladies and gentlemen, you don't burn down what you built up. Thank you.
All right, can you now call its first witness?
At this time, Your Honor, the prosecution calls Detective Williams. Your Honor, permission to set us a well.
Your Honor, permission to move about the well as the monster aids are being used.
Yes.
May I proceed? Please, introduce yourself to the members of the jury.
Good afternoon, members of the jury. I'm Detective Daniel Weber, but I usually go by Dan.
Where do you currently work?
I've been with the BCPD, Breckenridge County Police Department, for about 11 years now. And honestly, I couldn't be happier with my career.
And what do you do with the Breckenridge County Police Department?
I'm an arson investigator, so I work closely with law enforcement and first responders to identify cases of arson.
Detective Weber, what is arson?
Well, in simple terms, arson is the act of knowingly setting a property on fire. It's my job to understand that overlap between the science and the crime.
What's your educational background?
I earned my Bachelor's of Science from the Ohio State University. Then I went on to Penn State and earned a Master's in Forensic Science. After about 2 years of training, I became a licensed arson investigator.
What does an arson investigator do?
You can think of us as detectives, but specifically for fire. We're called out to a scene after a fire has occurred in order to assess the damage, locate the source of the flames, but ultimately to determine whether or not that fire had been intentionally set.
Detective, can you tell us about your role in today's case?
Sure. I was tasked with investigating a suspected case of arson at a local dive bar. The regulars call it Chuggies. But I'm also here to discuss my official case report.
How did you prepare that official case report?
I used the federal standard method for arson investigation. Back at the station, we used a checklist with 3 main steps. I actually brought that checklist with me here today to better outline how I investigate arson.
Your Honor, permission to display an awards version of the arson checklist.
Permission granted.
Detective Weber, could you walk us through what this is?
This is the standard method for arson investigation. First, we have an analysis of the scene. Then, an identification of any possible accelerants. And finally, a discussion of any alternative possibilities. This method allows me to properly apply my expertise and utilize any evidence from the scene, either physical or canine detected.
I'd like to start from the beginning of your investigation. Did you find any evidence of arson at Chuggy's bar?
Yes, I did. All of that evidence goes towards the first step, the method, the analysis of the scene.
What evidence did you review in your analysis of the scene?
Once the building was safe to enter, I began by taking photos. Then I reviewed the char marks on the floors, walls, ceiling. Finally, I collected witness statements. I always try to incorporate as much information as possible.
Detective, would you recognize some photos of Chuggy's bar after the fire?
Yes, of course. I took most of those photos myself.
Your Honor, permission to approach opposing counsel. What's been pre-marked as Exhibits 13 and 17?
Yes.
Would Your Honor like a courtesy copy?
Yes, please. Thank you.
Detective, what have I just handed you?
These are pictures of the kitchen and the ceiling at Chuggy's bar after the fire has occurred.
Are these fair and accurate representations of those pictures?
Yes, they are.
At this time, Your Honor, the prosecution moves exhibits 13 and 17 in evidence.
Any objections?
No objections, Your Honor.
Until we move into evidence.
Your Honor, permission to display an enlarged version of these exhibits.
Commissioner Graham.
What are these photos we're looking at here, tell me?
As you can see here, a large amount of exposed wood in the kitchen has been burned by the fire. The intensity of those char marks and the fire patterns strongly indicate that the kitchen was the origin of those flames.
What did you initially suspect caused the fire at Chuggy's?
When it comes to small commercial structures, dive bars for example, we often see fires started by things like faulty electronics. Faulty electronics can set off a spark, which then starts a flame. So I began my investigation there.
What did you discover?
I found no signs of structural failure to either the electrical box or the gas pipelines.
Why does that matter, Detective?
Well, given that the building was unoccupied at the time of the fire, the likelihood of an accidental fire by human error, a lit cigarette for example, is extremely unlikely. So the only real possibility would have been an electrical or a gas fire.
Did the evidence in today's case support that possibility?
No, it didn't. As I said before, there was no evidence that there was structural damage to either the gas pipelines or the electrical box. This led me to explore the idea that the fire could have been intentionally set.
Were there any other signs that the fire at Chuggy's was intentionally set?
Upon our initial investigation, this was unclear. But once I suspected arson, I called in a team of canine units to further search the premises for fire accelerants. That's the second step in our methodology. These dogs are specifically trained for cases of arson.
Did the canine units find any fire accelerants at the scene of the fire?
Yes, one of the canine units alerted us to the presence of an accelerant in the kitchen. That's where I sent in my first sample to be tested by the lab.
And what were the results of those lab tests?
The lab results revealed that the substance in the kitchen was actually a paint thinner, a commonly used type of fire accelerant. This paint thinner was almost chemically identical to a brand called Skinny's. There were also a lot of empty Skinny's paint thinner cans at the scene.
Is Skinny's paint thinner easily accessible?
Sure, we could go pick up a can right now actually. They're sold at Harlow's hardware store. I spoke with the owner of the store for this investigation to see if anybody had purchased paint thinner recently.
Were there records of anyone purchasing that paint thinner recently?
Yes, I'm able to confirm that the defendant in this case, Dakota Sutcliffe, purchased a few gallons just a few days before the fire.
Detective, could you explain your final conclusions in today's case?
I could better explain this if I use the checklist I brought today.
Your Honor, permission for the witness to step down and make use of the visual aid.
Commissioner Graham.
Detective, you were explaining your final conclusions.
Yes. Well, based on the analysis of the scene, the identification of a fire accelerant in the kitchen, and the ruling out of any alternative possibilities that could have caused that fire, I'm able to determine that today's fire was the result of arson and intentionally set.
Thank you, Detective. You may take your seat. Your Honor, I have no further questions. I just ask that this exhibit be demonstrated aid be preserved for closing arguments.
Sure.
Would you please counsel like me to start with the visual aids?
Yes. May I proceed?
Go ahead.
Good afternoon, Mr. Weber.
Good
I'm
afternoon.
just going to ask you a few questions about your investigation, if that's all right.
Absolutely.
Let's start with the delays in your investigation.
Sure.
You were alerted of a fire in Midland Center on August 1st, 2020.
Yes, I was.
You were alerted of this fire at 12:36 in the morning.
Yes, that's correct.
You went to Chuggy's that night where the fire was located,
Yes.
and you watched the fire from the outside of Chuggy's.
No, I was on the scene and actively interviewing people at the fire scene.
Mr. Weber, redirecting back to my question, you were watching the fire burn at Chuggy's.
I did not go into the building.
Exactly, Mr. Weber. You weren't inside Chuggy's at this time.
The fire was still raging inside the building.
That's a yes to my question, Mr. Weber. You weren't inside.
Sure.
Which meant you weren't investigating the fire origin or cause at this time, right?
It would have been impossible to investigate the fire while the fire was still burning.
That's a yes to my question, Mr. Weber.
Yes, I suppose so.
And at 1:06 in the morning was when your superior, Sergeant McDonald, was interviewing witnesses.
That's correct.
You didn't interview any witnesses that night.
No, I interviewed witnesses that night.
Is it your testimony that you interviewed witnesses that night?
Yes, it is.
Which witnesses did you interview, Mr. Weber?
The names are not on my report, but I interviewed witnesses that night. The fire was burning in the background. There were things falling. It was very cool scene.
Mr. Weber, you didn't interview Skylar DeJohn that night.
No, I did not.
You didn't interview Kieran Singh that night.
Well, my job is an arson investigator.
Mr. Weber, you've brought up multiple times in this court that you interviewed witnesses. You didn't interview Kieran Singh that night.
It's my testimony that I interviewed witnesses. We can go over that if you would like.
Mr. Weber, that's a yes. You did not interview Kieran Singh that night.
No, I did not that night.
You didn't interview Maddox Vaughn that night.
No, I didn't.
You didn't interview Ms. Sutcliffe that night.
No, there was no need to.
Now, your superior, Sergeant McDonald, he interviewed witnesses, but you didn't receive any interview transcripts from him.
No, I didn't.
At the time Mr. McDonald was interviewing witnesses, you witnessed Chuggy's partially collapse, right?
Yes, that's correct.
And since you watched it collapse from the outside, you weren't inside of Chuggy's,
No, that would have been extremely dangerous.
which meant you weren't investigating the origin or cause of the fire.
Objection, Your Honor, to ask and answer.
You can ask again.
Mr. Weber, since you were outside of Chuggy's at the time it collapsed, that meant you weren't inside of Chuggy's.
I think we established that if I was inside the building during the collapse, I would have been in a very dangerous situation.
Mr. Weber, my question wasn't whether we established it, it was whether you were inside or not, to which you were not,
No, I was not inside the building during the fire.
which meant you weren't investigating the origin and cause of the fire.
Not during the fire.
Now, at 1:45 a.m., the fire was fully extinguished by the first responders.
Yes, that's correct.
And at this time, the search and rescue process for Mr. Jalen Williams commenced.
Yes, it had.
You weren't a part of this search and rescue team,
No, I saw the body after it had been retrieved.
which meant you weren't inside Chuggy's at this time with the team.
Once again, just minutes after the fire had been extinguished, it's still a very dangerous situation.
That's a yes to my question. You weren't inside Chuggy's at this time,
That's correct.
which meant you weren't investigating the origin and cause of the fire at this time either.
No.
You would agree with me that the longer fire burns on, the harder it is to determine the origin of the fire.
Yes, but there's also more evidence.
You would agree with me that the longer a fire burns on, the harder it is to determine the cause of the fire.
I suppose so.
You would also agree with me that over an hour and a half had passed from when you were alerted of the fire to when you even began your investigation.
During which most of the time the fire had still been burning.
Now, Mr. Weber, let's talk about the difficulties in your investigation. Chuggy's partially collapsed that night.
Yes, it had.
That collapse caused significant and extensive exterior damage.
Yes, that's correct.
It also caused extensive interior damage as well.
It had.
This interior damage came through the form of significant amounts of debris, right?
Yes, there was plenty.
There was debris in the kitchen.
There was.
There was debris in the small storage area.
There also was.
There was debris on the stairs.
Yes.
There was debris in the hallway, too.
Yes, there was.
You would agree with me that debris inside of a building makes your job as an arson investigator much more difficult.
I would disagree.
You would disagree that debris makes an investigation more difficult?
Yes. Debris is evidence, and evidence makes an investigation easier.
Is that your testimony today, that debris inside of a building makes an investigation easier?
Yes, that is.
I'm approaching opposing counsel with Mr. Weber's report. Mr. Weber, when you investigated the fire at Chuggy's that night, you determined that the origin was in the kitchen.
That's correct.
And there were a couple reasons why you determined the origin was there, right?
Yes,
The first was because a canine unit detected accelerant in the kitchen.
that's correct.
But canine units are imperfect.
Canine units are the most dependable source we have.
That wasn't my question. Canine units are imperfect.
Sure, you can say that.
It's possible that night that the canine units erred.
No, I sent in a sample to the lab, and it explicitly told us that the substance was a paint thinner.
Irrespective of the sample, though, those canine units could have erred that night.
No, they alerted us to a substance, which was then proved to be a paint thinner.
The second reason was because there were containers in the kitchen.
Sure, yes, there were containers in the kitchen.
You don't know how those containers got there.
No, that's not my job as an arson investigator.
You don't know what was in those containers.
They were paint thinner containers with traces of paint thinner.
But you don't know whether any paint thinner was in there previously.
No, we can't say that.
You don't know who used those containers.
Again, it's not my job as an arson investigator.
That's a no to my question.
Sure, that's a no.
You don't know who purchased those containers.
No, I can reliably confirm that Dakota Sutcliffe purchased those containers a few days ago.
The owner at Harlow's Hardware didn't tell you that the containers found in the kitchen were the same ones purchased from Harlow's.
No, they were identical.
They were identical, but she didn't tell you those were the ones purchased by the defendant.
Sure, we can say that.
You also don't know if those containers were placed by firefighters that night.
Once again, that's not my job as an arson investigator. But I would find it highly unlikely that firefighters putting out a fire would bring in cans of paint thinner.
Once again, that wasn't my question. You don't know if the firefighters inside the building had moved those containers to the kitchen.
No, I wouldn't know that.
Now, Mr. Weber, you would agree with me that over the course of your investigation, you reviewed no evidence indicating that Ms. Sutcliffe set fire to Chuggy's.
No, I did not.
You would also agree with me that over the course of your investigation, you reviewed no evidence indicating any reason as to why Ms. Sutcliffe would want to set fire to Chuggy's.
Again, that's not within my scope as an arson investigator to determine why somebody would want to set fire to a bar.
Again, Mr. Weber, that's a no to my question. You reviewed no evidence indicating why Ms. Sutcliffe, even if she did, would want to set fire to Chuggy's.
I reviewed plenty of evidence.
That wasn't my question. You reviewed no evidence indicating why Ms. Sutcliffe would ever want to set fire to Chuggy's.
Sure, we can say that's enough.
You can't tell the members of the jury who did it,
No, I cannot.
and you can't tell the members of the jury why that person did do it.
Again, that's not my job, but I suppose I can.
No further questions at this time.
Can you read that?
No, you're wrong. I just asked that the witness be allowed to take a seat.
You're excused.
The prosecution calls its next witness, Ms. Skylar Dijon. May I proceed?
Go ahead.
Please, introduce yourself to the members of the jury.
Hello, my name is Skylar Dejean.
What do you do for a living?
I recently graduated from Midland State University in December of 2019 and have a degree in the performing arts. Some people would consider me to be unemployed, but I like to think of it as an opportunity to pursue my passion. Broadway.
How are you involved in today's case?
I used to be a bartender at Chuggy's. That's where I met Dakota.
What's your relationship to Dakota Sutcliffe?
She was the owner of Chuggy's bar, so she was my boss.
Can you identify the defendant by an article of clothing?
Sure, she's wearing a plaid jacket, blonde hair.
Let the record reflect that Ms. Dijon has correctly identified the defendant. How did you come to know the defendant?
Dakota was my boss when I worked at Chuggy's bar. Bartending has always been an interest of mine. You know, a lot of famous actors started off as bartenders. You never know who's gonna walk through that door and then, bam, you're a star.
What was it like working at Chuggy's with the defendant as your boss?
Horrible. What people want is a good dive bar with cheap beer, not some upscale beer garden Dakota was trying to make.
How did these changes affect you as a bartender?
Dakota's big plans to renovate, Tips went down and hours went up.
When did these renovations happen?
Dakota closed Chucky's for most of December for the renovations. Dakota promised the staff to reopen in time for our New Year's Eve bash, but we didn't end up reopening until a week into January.
Once you did reopen, what was business like?
Our reopening was pretty underwhelming. We had to close immediately because of that giant ice storm. After that, business was slower than rush hour in the city. When I went back to work, I started to think that the business was in a serious hole.
Why do you say that?
I overheard Dakota on the phone saying, "I'll be able to make payments. I promise. I just need a little more time." And my suspicions were confirmed when he asked us all to take a pay cut.
How long did you have to take a pay cut?
Not long at all. Dakota fired me.
Mr. Jean, why were you fired?
On March 9th, Midlands had its first confirmed COVID case. And a week later, Midlands issued the stay-at-home order because of COVID. So what does Dakota do? He fires me. Fires me? I had to move back in with my parents.
Was that the last time you saw the defendant?
Oh, I'm sure he wishes that was the last time. But unfortunately for her, Midlands is a small town. And when I saw her again, I was ready to give her a piece of my mind.
When did you see her?
It was in July. She was sitting in her truck and I overheard her talking on the phone.
What did you hear her say?
She said she didn't know how to cover the loan and she wasn't sure if the insurance payout would be big enough. All I gotta say is she was lucky she was talking on the phone because I was ready to tell her off. Still, I must have scared her away because she looked me in the eyes and she was out of there faster than the Red Sox hopes at making it to the playoffs.
Mr. Jean, I want to talk to you about the night of the fire at Chuggy's. Where were you that night?
It was around midnight. I was taking my usual walk downtown. It's the only time I can get any kind of peace and quiet from my mother constantly nagging me.
Did you see anyone?
Yes, I saw Dakota.
How did you know it was the defendant?
The way they walked gave it away. I even saw part of her face, and from what I saw, it was Dakota.
Where did you see her go?
She exited Chuggy's bar from behind and walked to the firehouse. I mean, I don't know anyone else who would go from Chuggy's bar to the firehouse.
What do you mean by that?
Dakota was a volunteer firefighter. She would constantly brag about it at Chuggy's.
Now, when you saw the defendant arrive at the fire station, what happened?
Well, when Dakota got to the fire station, the alarm started going off. Dakota slipped inside. Next thing I know, the garage door started open, fire trucks started peeling out, sirens blaring. That was a little too much for me, so I decided to head home.
Thank you, Mr. Jean. I have no further questions at this time.
May I proceed, Your Honor? Go ahead. Now, Mrs. Jean, you began working at Chuggy's in 2018, correct?
Yes, from
Sorry.
it's fine.
Please finish.
From the previous owner, Mr. Jordan James.
And that means that you were working at Chuggy's whenever Dakota took over the place in 2019, correct?
Yes, I was working at Chuggy's when Dakota took over.
Now, your previous boss, who you mentioned, Jordan James, had a more laissez-faire attitude when it came to management at Chuggy's. You would agree?
Yes, Jordan was very chillaxed.
Jordan didn't enforce many rules at Chuggy's.
I guess you could say that, but people love the charm of Chuggy's, you know?
So that's a yes to my question. And Jordan did not have very high standards for Chuggy's.
Yes,
He allowed you to sneak in your underage friends.
at times, yes.
He allowed you to give out free
Objection, relevance.
Your Honor, this is extremely relevant to today's case as it attests to the character of the witness on the stand and also shows the difference between management before Dakota and, if I may proffer, as I get to subsequent questioning, it will show how it is comparable to Dakota's management in the future.
May I respond? Yes, Your Honor. Simply talking about the management style of the previous owner, Jordan James, that makes no fact in today's case more or less likely. If the defense would like to go into the management style of the defendant, they can do so without bringing up previous management.
Response, Your Honor.
Yes.
Like I said previously, this attests to the overall character of the witness, considering that she did give out free food and drink and would let in her underage friends. This is not specifically speaking to the management style of Jordan James. And then, as I said previously, it also will coincide with my subsequent line of questioning regarding Dakota Sutcliffe's management style.
Overruled, you may proceed.
Now, let me ask you that question again. You were allowed to give out free food and drink under Jordan James' management.
Sure.
Now, when Dakota took over, all these things changed.
Yes, they did.
You could no longer let in your underage friends.
No,
You could no longer give out free food and drink.
no,
Dakota was very strict when it came to enforcing rules.
he was.
And Dakota had high standards for Chuggies.
You could say that. I mean, he just wanted to change the entire structure of the place. But everyone loved the charm of Chuggies.
Now, Dakota eventually decided to do some renovations to Chuggies, correct?
Yes.
Now, these renovations led to you taking a dip in your tips.
Yes. I mean, the regulars just didn't like what Dakota was doing.
Your hours also increased.
Yes, they did.
It's fair to say you weren't a fan of these changes, Mr. Jean.
I was not a fan.
You also do not like Dakota Sutcliffe, do you?
I mean, we didn't agree on, views for the bar.
So that's a yes to my question. You did not like Dakota Sutcliffe.
As a boss, not really.
And you are aware that Dakota Sutcliffe is the defendant in today's case.
I am.
Now, I'd like to talk to you a little bit about the night of July 31st. You decided to take a walk that night, correct?
Yes.
You were in a public place, correct?
Yes, I was.
Now, you claim to have seen someone across the street.
I saw Dakota, yes.
Now, it was dark outside, correct?
It was, but I could tell it was Dakota just from the way that she wore.
That's a yes to my question. It was dark outside.
Yes, it was dark. It was around midnight.
And there weren't many street lamps around.
No, there weren't, but your eyes just adjust.
And you only saw parts of this person's face.
Yes, but the parts that I saw made it pretty clear that it was Dakota to me.
And you never saw this person in their entirety.
No, I did not.
Now, Mrs. Zhang, you can't sit here and say with 100% certainty who this person was.
Not with 100% certainty, but I'm pretty sure I saw Dakota.
Mr. Zhang, you can't even put a percentage on it.
I mean, I guess I couldn't, but I'm pretty sure it was Dakota.
Now, Mr. Zhang, the night of the fire, you did not see anybody use any fire accelerant, did you?
No.
You did not see anyone set a fire at Chuggies.
No.
And you cannot sit here today and tell the court how the fire at Chuggies started.
No. All I can tell you is that I'm pretty sure I saw Dakota leaving Chuggies and going to the firehouse. And then
So that's a yes to my question, Mr. Jean. You cannot sit here today and tell the court how the fire at Chuggies began.
I suppose I couldn't do that.
Thank you. No further questions, Your Honor.
Any redirect?
No redirect, Your Honor. Just said Mr. John be excused.
You're excused.
At this time, the prosecution calls Norcon to the stand. Permission to set up a demonstrative in the well.
Go ahead.
Please, introduce yourself to the members of the jury.
Hi, I'm Nora Khan.
What do you do for a living?
I'm a detective for the Midlands Police Department. I'm in the White Collar Crimes Division, so I primarily deal with cases involving fraud.
Can you tell us a bit about your educational background?
Sure. I was in the Navy for about 4 years. Decided I wanted to take on an even tougher challenge, accounting. So I went back to school, got my CPA. Now I'm a forensic accountant for the police department. I've been doing that ever since.
What exactly does a forensic accountant do?
I always tell people it's kind of like the crime show CSI. The forensic scientist has their flashlight in hand and they're scanning the crime scene for clues. Forensic accountants do the same kind of work, only in the financial world. We take that same flashlight and we look for clues, only in financial records for fraud.
What is fraud?
Speaking very broadly, fraud is the act of deceiving others for financial or some type of personal gain, basically lying for profit.
Did you find any fraud in this case?
Well, I found suspicion of fraud, yes, against the owner of Chucky's Bar, Dakota Sutcliffe.
How come?
After the defendant was arrested for suspicion of arson, that's when I was brought in to determine if he had any motive to commit fraud.
What of the defendant's financial records did you review?
I reviewed her financial statements, but primarily focused my investigation on her primary bank account associated with Chuggy's Bar specifically.
What did you find in that information?
I found a series of things, but specifically found that the defendant had taken out a $1 million loan and a $1.5 million insurance policy using certain transaction methods standard in my field. I flagged both of those things as substantial risks.
How did you use that method to flag those as risks?
Well, it's typical in my field to flag any transaction over just $100,000. So when I saw a loan taken out for $1 million and an insurance policy taken out for $1.5 million, those certainly caught my attention. Transactions like those require substantial monthly payments.
Now, Detective Khan, I want to take each of those risks one at a time.
Sure.
Let's start with the loan payment. What does it tell you when a person takes out a loan of that size?
Well, just because someone takes out a loan doesn't mean they're committing fraud. But in this case, the defendant had taken out a $1 million loan. She began to struggle financially and she stopped making payments on those loans.
Do you know why the defendant stopped making payments?
I do. I pulled information directly from her financial statements and used that to create a timeline of certain loan payments.
What type of information did you gather to create this timeline?
I pulled months and dates from those financial statements, determining whether or not the defendant paid or didn't pay. And then I used it to create a timeline of her loan payment history. I brought that visual with me today.
Your Honor, permission to make use of a demonstrative aid at this time? And permission for the witness to step down?
Your Honor, permission to approach to see if I reviewed the demo.
Go ahead.
Detective Khan, can you walk the members of the jury through this timeline?
Certainly. So from here in November to February, the defendant was making payments on time, as she should. And then here in March, she makes a partial payment. And then here in April, she stops paying her loan altogether.
Do you know why this shift occurred?
I do. Based on my review of correspondence between the defendant and her financial advisor, I pulled information directly from those email correspondence and used it to put it here within this timeline.
Would you recognize those emails if I showed them to you today?
I would.
Your Honor, permission to approach opposing counsel with Exhibit 6, which per stipulation 9 has been pre-admitted.
Go ahead.
Would Your Honor like a courtesy copy?
Yes, please.
Now, let's take a look at each of these emails, shall we? And let's start in May. What type of information did you find in this May email?
Right, so the first email we got was from Meg. And here, this email was sent after the defendant had missed 2 loan payments without reason. And she says in that first email in May, unless I'm granted some type of furlough or loan forgiveness options, the bank isn't seeing a dime.
What is a furlough?
When the bank recognizes that someone is struggling financially, they'll grant them a certain grace period in which that client doesn't have to pay. But once that grace period ends, they have to pay back in full from all the time that they didn't pay.
Was the defendant granted a furlough?
She was,
Until when?
until June.
Now let's take a look at that email from June. What did that email show you?
Well, here the bank said that her furlough was up. She had to pay back the bank everything she owed. But then she writes an email and says, our business is down and I don't have the money to pay.
How did the bank respond?
They were willing to work with the defendant. They extended her furlough
For how long?
until August.
Now let's take a look at that final email from right before the furlough was set to end. What did this email show you?
So an email was sent to the defendant that said her furlough was up.
How did the defendant respond to that notice?
She said, it is what it is. I don't have your money.
If the defendant doesn't pay back what they owe by the time the furlough ends, what happens?
So she would lose whatever she put as collateral. So in this case, she had put Chuggy's bar up for collateral. So she didn't make those payments, she would lose the bar to the bank.
Do you know if the defendant paid back that money?
I do. She did. She doesn't give a reason as to why.
What else happened what happened instead when that payment was due?
She never gave a reason, but that same day the payments were due was the same day her bar went up in flames.
Thank you, Detective Khan. Can now we take your seat? Now I want to talk about that second risk you mentioned,
Sure.
the insurance policy. Was the defendant making payments to the insurance company?
Yes. Chuggy's bar was fully covered. Unlike the loan agreement, the defendant was making payments on time and in full.
What do you mean Chuggy's was covered?
So according to the insurance policy, it stated that if Chuggy's were to burn down due to a natural fire, the defendant would receive some type of compensation.
Do you know what actions the defendant took after the fire at Chuggy's?
Yes, she filed for an insurance claim.
Why was this claim important?
Well, the issue wasn't the fact that she had filed an insurance claim, it's just when it was filed. She couldn't make the payment she owed the bank on August 1st. That same night, her bar went up in flames. That very next day, she was seeking compensation, claiming there had been a natural fire.
Detective Khan, how much would the defendant stand to gain if that insurance claim was approved?
She stood to gain $1.5 million.
Thank you, Detective Khan. I have no further questions at this time, Your Honor. Would opposing counsel like me to take strong silence?
Yes, please.
Hi, Detective Khan, how are you?
I'm doing well.
I want to start off talking about some things you guys just mentioned. First off, you said that if Ms. Sutcliffe did set the fire, she was going to make $1.5 million on the insurance policy.
No. If the bar were to burn down due to a natural fire, she would receive a compensation.
Of $1.5 million.
Right.
But you're aware that the policy actually operated differently, that it was on a sliding scale, depending on the renovations that were going on.
What do you mean by like a sliding scale?
The payment, the insurance policy was worth $425,000 to $1.5 million.
Right, so the defendant had made renovations to her bar, which increased the value of the money she would get, so she would get about 1.5.
But you're aware that she hadn't finished renovations by the time that Chuggy's burned down on August 1st, right?
She had made extensive renovations.
But that's the yes to my question, the renovations were not finished.
Well, I wouldn't know if she if she planned on making more renovations, maybe, but I wouldn't know.
You wouldn't know if the renovations were not fully completed by August 1st.
Not to my knowledge.
And if they weren't fully completed, she wouldn't have received that full $1.5 million.
Possibly not, no.
Now, you reviewed my client's finances for fraud,
Right, I reviewed several financial statements, correct.
and this requires expert level knowledge of various kinds of fraud.
Yes.
Yet, you failed to receive your accreditation as a fraud examiner.
No, I'm a forensic accountant.
So you're here examining my client's finances for fraud, but you don't have the accreditation to do that.
Not the accreditation, but as a forensic accountant for the Midlands Police Department, I'm qualified to determine her motive for fraud, yes.
So that's a yes to my question, you don't have that accreditation, right?
No.
Now, like you said, you reviewed some emails from the bank to Ms. Sutcliffe.
Yes.
Specifically, you reviewed one from the bank's loan officer to Ms. Sutcliffe on July 15th.
Correct.
And this was 2 weeks before the fire.
Yes.
And in this email, the bank said that Ms. Sutcliffe had to pay the interest on her payments by August 1st.
Correct.
But Ms. Sutcliffe actually had 2 more weeks to fulfill her entire payment.
She did.
So, by August 1st, she still had time to give the money back to the bank.
Well, her payments were due, but by the time the bank would actually confiscate her bar, yeah, she had some leeway.
Now, you received a year's worth of financial data from Chucky's,
Yes.
but you only reviewed 6 months of that.
I received the entire year, but only focused my investigation on the last 6 months, correct?
Okay, and that's because you found no indication of fraud based off of those 6 months.
Within her tax statement specifically, yes. No indication.
You found no indication from any of the documents you reviewed.
I found the defendant had motive to commit fraud.
But that's a yes to my question. You found no indication from any of the documents you reviewed that Ms. Sutcliffe committed fraud.
That's not true.
It's your testimony today that you found an indication that Ms. Sutcliffe committed fraud?
That she had a motive to commit fraud.
Detective Kahn, that's not what I'm asking. I'm asking, you did not find a single indication from any of the documents you reviewed that my client committed fraud.
Right, not fraud, just a motive.
So that's a yes.
Yes.
Now, you've never been to Chuggy's.
No.
You've never talked to my client.
No.
So you didn't see Ms. Sutcliffe with any paint thinner.
Objection, Your Honor. Misleading the jury.
Yes, Your Honor. My next question was going to be if she saw Ms. Sutcliffe set fire to the bar. I was just getting up to that.
I'm gonna go ahead and overrule it.
So you didn't see my client set fire to Chuggy's on August 1st, right?
No, I didn't.
And even if there was any indication of fraud on Ms. Sutcliffe's part, you could not relate that indication to the fire that occurred on August 1st, could you?
I don't understand your question.
Even if you did find an indication that Ms. Sutcliffe committed fraud, you could not relate that indication to the fire that happened on August 1st.
Objection, Your Honor. Lack of personal knowledge. May I be heard?
Yes.
The witnesses here testifying that her expert conclusion, which she formed and explained for us today, is that there was a motive to commit fraud. She is not an expert in testifying that the defendant set fire to Chuggy's or had anything to do with the fire. She's simply saying what the motive for fraud would have been.
Response, Your Honor.
Yes.
We're here today to determine if Ms. Sutcliffe did set fire to her bar or not. Detective Kahn is on the case to see if she had fraudulent behavior because she set fire to the bar, because she wanted to get money out of it. If Detective Kahn can relate that fire to the fraud, then it's extremely relevant for the jury to understand that.
Response.
Go ahead.
It is not, Detective Kahn is not an arson investigator and would not have the knowledge to know whether or not the defendant set fire to Chuggy's. She's simply here to review the defendant's financial records and base that information on her conclusion. Base her conclusion on that information today. She's not here to testify to whether she saw the defendant set fire to Chuggy's or even believes that the defendant may have set fire to Chuggy's.
Quick response, Your Honor.
Last word.
I'm not asking Detective Kahn to tell us anything about the specifics of the fire. I'm just asking her if her investigation of this case and if her conclusions can relate to the fire, which we're here today to discuss.
Overruled.
I'll ask again. Even if you did find an indication that my client committed fraud, you could not relate that indication to the fire that occurred on August 1st, 2020.
That's incorrect.
It's incorrect.
Yes.
So how would you relate the fire at Chuggy's to the fraud?
I found the defendant had financial motive due to her missed loan payments, due to the money she would have gained from that insurance policy, that she would have the motive to financially benefit from the fire at Chuggy's bar.
I'll ask again. You didn't find any indication of fraud.
No, just motive.
Okay, no further questions.
Any redirect?
No redirect, Your Honor. I just asked that Detective Conklin step down.
Your excuse.
And at this time, the prosecution rests our case in chief and asks for a brief 5-minute recess. Counsel then.
Go ahead. I have the time at 3:15, so if everyone's back by 3:20. Thank you.
tight ship, Judge.
My mom's a district court attorney, and so I was texting her. I was like,
Oh,
I
she
need to
is? Who's your
Yeah.
mom?
Huh?
Who's your mom?
It's in North Carolina.
Oh.
Joel Brown.
Okay. Wow. I had a big case in Nashville.
Mm-hmm.
It's been a while.
That's cool.
That was a good excuse to spend time in Nashville.
Yeah, no, Asheville's so pretty. I live around where like UNC is.
Okay. See yourself going that way?
Yeah, definitely.
Yeah, definitely.
Both my parents were public defenders for a while, and my dad's still, or like kind of PD who does death penalty cases. And yeah, I really like it. I've been involved in a lot of like my dad teaches trial ad, so I always go to his stuff and help him with that. I love it. It's great.
Your legacy. Tom's all awesome.
Yes. Either 5 or 5:15. I really couldn't hear the end. I was like, I don't know, maybe. Should we?
Those things really come off the rails.
Also, are you okay with this behind you? Is like the beeping here? Or we can move over there.
Keep away.
Thank you.
On and creating your expert report.
Along with D. Weber's initial report, his diagram of chuggies, and his photographs from the scene, I also reviewed the affidavits of Alex Silva, Karan Singh, Maddox Vaughn, and Tobin Johnson.
Did you use any principles or methods in coming to your conclusion?
Yes, I did. I used the FOIA method, F-O-I-A. It's the standard method for fire origin and analysis in my field. It's actually considered to be the gold standard. It's an acronym and it has 3 parts.
Could you explain the first part to us?
FO, which stands for fire origin. This is where I determine any factors that would go into determining the origin of the fire.
What's the next part?
I, which stands for identification. This is where I identify any factors, circumstances, materials that could help me determine the origin of the fire.
What's the final part of the FOIA method?
A, which stands for analysis. This is pretty straightforward. This is where I analyze the evidence in sum and determine the origin and cause of the fire, if there is one.
Ms. Saeed, what do you mean, if there is one?
It's important to be careful and accurate when evaluating fires, especially if there is suspicion of arson, like there is in this case. Sometimes the origin and cause of a fire may very well be undetermined.
Why is this important?
This is important because fire can spread from surfaces that aren't even close to the original fuel source.
Did you reliably apply the FOIA method to the facts and data in today's case?
Yes, I did.
Ms. Saeed, what sources of information do investigators like yourself look at when determining the origin of a fire?
There are 3: witness statements, electrical patterns, and fire patterns.
Did Mr. Weber utilize witness statements in determining the origin of a fire?
No, he did not. He didn't interview a single witness when coming to his determination about the origin of a fire.
Did Mr. Weber utilize electrical pattern analysis in determining the origin of a fire?
Yes, he did, but his analysis of such was deeply flawed.
Ms. Saeed, I want to make sure this is clear for the members of the jury. Electrical pattern analysis, did Mr. Weber utilize that when determining the origin of a fire?
No, he did not.
Could there have been this effort?
Certainly. There are electrical appliances in the bar, the dining room, and the basement of Chuggy's bar, and we have no idea whether the electrical currents running throughout Chuggy's bar could have started or contributed to the fire that night.
Let's talk about the last source of information, fire pattern analysis. Did Mr. Weber utilize that when determining the origin of a fire?
Yes, he did, but his analysis of such, because of the building being partially collapsed, was very unreliable.
How so?
This is because as materials fall in a collapsed building, they continue to burn as they fall, causing more charring.
Is there any other reason why Mr. Weber's fire pattern analysis was deeply flawed?
Yes. Because the building was partially collapsed, the preservation of the building was completely compromised, and preserving any possible evidence is also very difficult. This means that the fire patterns provide no basis that the fire actually originated in the kitchen of Chuggy's bar.
Is there any other source of information that investigators like yourself look at when determining the origin of a fire?
Other than witness statements, fire pattern, and electrical pattern, no.
Are there any effects that can happen during a fire that can affect what an investigator views as the origin of a fire?
Yes. The flashover effect, which is the type of fire.
What is the flashover effect?
A flashover is simply a transitional phase. This is where fire jumps or moves across different surfaces in a room.
Why is the flashover effect important?
It can make our job as investigators more difficult. A better word would be confusing.
How so?
This is because as a flashover occurs, it can be difficult to tell whether the fire patterns are from the original fire patterns or if the fire patterns are from a flashover effect occurring.
Let's move on to the causal portion of your analysis, Ms. Saeed. What sources of information do investigators like yourself and like Mr. Weber look at when determining the cause of a fire?
There are a few. When determining the cause of a fire, we typically look at ignition source, first fuel, and ignition sequence.
Were you able to determine the ignition source for the fire at Chuggy's Bar on August 1st, 2020?
No, I was not. All potential ignition sources, such as faulty wiring, were not considered. Therefore, ignition sequence is undetermined.
What about the next one, the first fuel? Were you able to determine the first fuel for the fire at Chuggy's?
No, I was not. The first fuel could have theoretically been any flammable substance in the kitchen or the storage area. Therefore, I determined first fuel as undetermined.
And finally, ignition sequence. Were you able to determine that for the fire at Chuggy's?
No, I was not. The original investigators determined ignition sequence through use of chromatographic analysis on samples of paint thinner found in the kitchen of Chuggy's Bar. There were many things they didn't consider, though.
What did they not consider?
For example, the fact that renovations had been occurring in the kitchen of Chuggy's Bar, which would
To hearsay?
May I respond?
You may.
As you are aware, Your Honor, under Rule 703 and pursuant to relevant Midlands case law, more specifically Richards versus Mississippi Barbecue, experts are allowed to use otherwise inadmissible hearsay in forming their conclusions. Seeing that cause is one of two conclusions that Ms. Saeed is here to discuss, this testimony is allowed.
Response from
Yes.
Although we agree that under Rule 703, experts can otherwise use inadmissible hearsay to come to conclusions, Ms. Saeed's expertise is specifically within fires and investigations. She has no knowledge of renovations or how that impacted the analysis of the scene. This is just something she's using, and this expert is effectively becoming a conduit to hearsay. It's an adequate statement to use the truth of the matter asserted because the defense needs to prove the case.
Brief response, Judge.
Go ahead.
Ms. Saeed does not need any expert knowledge on renovations occurring at Chuggy's in order to use that as one facet of her expert conclusion. In fact, all Ms. Saeed said was that renovations were occurring at that time. She's not going to testify to members of the jury about the extent of those renovations. It is the contention of the defense that the state just wants to keep this out for their hearing.
Response from
Final word.
Unless Ms. Saeed knew extensively about every single piece of renovation that happened at Chuggy's, it is impossible for her to say how those renovations could have affected the fire. There could have been so many different factors, including building structures being moved or things being changed. She does not have the information. It's out of court. It's being used for the truth of the matter. So,
Final word.
Yes, Your Honor. Again, it is our contention under Rule 703 that Ms. Saeed is allowed to say whether renovations are occurring. She is not going to go beyond the fact that renovations were occurring at that time, just simply the fact that renovations included flammable material in Chuggy's. There's no such thing as an expert on renovations, and the state's demands in regards to Rule 703 and the relevant Midlands case law is unfound.
I'm going to overrule it, but keep it to the bound of her knowledge.
Of course, Your Honor. Ms. Saeed, would you like me to ask that question again?
No, I believe I know what I was saying. Paint thinner was in the kitchen of Chuggy's Bar, or could have been in the kitchen of Chuggy's Bar because paint thinner was being used in the renovations. So that would explain the presence of the paint thinner in the kitchen. And moreover, if the paint thinner was accidentally spilled, that would explain why the chromatographic analysis samples came back as positive.
What was your expert opinion on the origin of the fire at Chuggy's?
I ruled the origin of the fire at Chuggy's Bar as undetermined.
What is your expert opinion on the cause of the fire at Chuggy's Bar?
I ruled the cause of the fire at Chuggy's Bar as undetermined.
Seeing that both of these things are undetermined in your eyes, could today's case be a non-arson case?
Precisely. Given the factual and physical evidence that is displayed here, we cannot rule out that this fire could have been accidental.
Ms. Saeed, did you review any evidence that Ms. Dakota Sutcliffe started the fire at Chuggy's?
No.
Did you review any evidence that even if Ms. Sutcliffe did start the fire at Chuggy's, she would have any reason to do so?
No.
Is there any test that investigators like yourself or Mr. Weber can use to look at a fire after it occurred and determine who did it?
To my knowledge, there is not. Even if this was arson, D. Weber nor I could tell you who started it.
No further questions at this time, Your Honor.
cross-examination, Your Honor. Good afternoon, Ms. Saeed. I just have a few questions for you. You were hired to investigate the fire at Chuggy's Bar, correct?
No, I was hired to investigate Daniel Weber's report of his investigation of the fire.
And in doing that, you went to the scene of the fire, right?
A few months later, yeah.
Right. You waited 3 months to go to the scene.
Yes.
In that time, there was no effort that was made to preserve the scene at all, correct?
That's correct.
There wasn't a cover placed over the burned down bar.
Nope.
The scene had materially changed.
Yes.
And you're aware that at the scene of Chuggy's Bar, there was fire accelerant found.
Yes.
Fire accelerant is used to make fires bigger. Do I have that right?
Well, it was paint thinner, which is not used to make fires accelerate, it's used to strip paint. But it does have the side effects when it is exposed to fire that it will accelerate a fire.
That's a yes to my question. Fire accelerants are used to make fires grow bigger.
That's correct.
And the fire accelerant in today's case, like you said, was paint thinner.
Yes.
Ms. Syed, you believe it's highly unlikely that paint thinner was in use at that kitchen before the fire.
I was not at Chuggy's bar at that point in time, so I can't tell you specifically where and when paint thinner was being used.
Ms. Syed, directing you back to my question, in your own words, you believe it's highly unlikely that paint thinner was used at Chuggy's bar before the fire.
Objection, Your Honor. This is hearsay. May I be heard?
Go ahead.
As you are aware, in relevant Midlands case law, America's Best Cookie versus International House of Waffles, even witnesses on the stand in their out-of-court statements being offered are still definitionally hearsay. That's exactly what opposing counsel is doing. He said, in your words, he's referring to Ms. Saeed's report, and unless rephrased, this is inadmissible.
Your Honor, I'm open to rephrasing the question.
Go ahead and rephrase.
Ms. Syed, do you believe that it's highly unlikely that that paint thinner was in use at Chuggy's before the fire?
Based on the testimonies that I read, paint thinner was used at Chuggy's bar.
Ms. Syed, is your testimony that you believe it's likely that paint thinner was used at Chuggy's before the fire?
Are you asking specifically about in the kitchen or just like at the bar in general?
In the kitchen specifically, Ms. Syed.
In the kitchen specifically, I thought you were asking about the bar like altogether. Okay. In the kitchen specifically, I don't see why it would be, but like it's a possibility.
But you believe it's highly unlikely, correct? Ms. Syed, I want to talk a little bit more about your role in today's case. You work for a private company.
Yes.
In fact, you own that company.
Yes, I do.
That company was hired by the defense in today's case.
Yeah.
You were paid to find problems with Detective Weber's report.
Objection, Your Honor, misleading to the jury. Under Rule 403, relevant evidence may be excluded so long as the prejudicial value substantially outweighs the probative value. Opposing counsel's line of questioning, the fact that defense counsel hired Ms. Saeed to find problems is utterly misleading to the jury as to her role in today's trial. It was to further review Mr. Weber's report, and there's little to no probative value in this line of questioning. It's simply prejudicial, and seeing as such, it substantially outweighs and is inadmissible under Rule 403.
Response, Your Honor.
Go ahead.
This question goes directly to what Ms. Syed was hired to do in today's case. Secondly, the bar 4403 is extremely high, Your Honor. The prejudicial effect has to substantially outweigh the probative value. The probative value of this question is clarifying to the jury what this witness was brought in to do. That was to review Detective Weber's report. That's exactly what the question asked.
Last response, Your Honor.
Go ahead.
That's not how opposing counsel phrased his question. He phrased his question as in Ms. Saeed was hired in order to find problems with Mr. Weber's report. She agrees with portions of Mr. Weber's report. She relied on many portions of Mr. Weber's report. She was hired to review and provide her own opinion and was not hired to find problems.
Response, Your Honor.
Onward.
This is cross-examination. The bar for 403 is incredibly high. The prejudicial effect does not by any means outweigh the probative value of this line of question, Your Honor.
Overruled.
Ms. Syed, you were hired to find problems with Detective Weber's report.
I was hired to review Mr. Weber's report.
Right. And in your review, you came and testified today that Detective Weber's conclusions were wrong.
I came here to testify today that his conclusions could have been wrong.
Ms. Syed, I'd like to talk to you about the contents of that report. You published it for today's trial.
Yes.
And in coming to that report, you had the final say, correct?
Yes.
In making this report, to be clear, you did not run a single test.
That's not what I was hired to do, so yes.
You did not speak to any witnesses.
That's correct.
You did not collect any physical evidence.
That's correct.
So the content of this report are your opinions.
That's correct.
Now, Ms. Syed, just so we're on the same page, You didn't have anybody peer review that report, did you?
No.
I'd like to talk about some of the things we talked about on direct examination. You mentioned electrical appliances, and you believe it's highly unlikely that electrical appliances contributed to Chubby's fire. Do I have that right?
That's correct.
And to be clear, you would agree that Detective Weber's report is the most detailed report we have of the original investigation.
Yes, that's correct.
And you have no reason to believe that in any way his report is biased.
No, I don't think so.
Thank you. Your Honor, I have no further questions.
May we redirect?
No redirect, Your Honor. We just asked that the site be excused.
You may be excused.
Your Honor, the defense calls Ms. Alex Silva to the stand. Good afternoon. Please introduce yourself to the court.
Hi, my name is Alex Silva.
What do you do for a living, Ms. Silva?
I work in the Midlands Department of Parks and Recreation, where my main focus is stopping the spread of wildfires. But my true passion is firefighting, so now I do both.
How do you do both?
Well, I don't get paid to run into burning buildings anymore. I volunteer with my old unit.
Where is your old unit?
My old unit is in the Midlands Fire Department.
Now, what did you do before going to the Midlands Fire Department?
Before I went to the Midlands Fire Department, I attended Calkins College, where I majored in structural engineering and environmental science.
And how long have you been with the fire department?
It's been about 9 years now. I joined the department the second I graduated.
And what does training at the fire department look like?
Our training is pretty intense, and it just shows a true reflection of our work. We were given a manual that outlines every aspect of our work.
Now, I'd like to pivot a bit and talk about August 1st of last year. Were you on call that day?
Yes, I was. My shift started in the evening of July 31st and went into August 1st.
Did you respond to any calls on your shift?
Just one. It was right after midnight. There was a structural fire
Where was this fire?
at Chuggy's Barn.
And were you familiar with this bar before you responded to the call?
Yes, I've been a couple of times. My fellow firefighter, Dakota Sutcliffe, owned it.
How long have you worked with Ms. Sutcliffe?
We met on the job in 2016, so it's been about 4 years now.
How would you describe your working relationship with Ms. Sutcliffe?
Dakota is great. She's an exceptional firefighter, and she's always taking extra shifts for her fellow firefighters whenever needed. She goes above and beyond her duties every time. She's the first one in and the last one to leave.
You said she goes above and beyond her duties. Could you tell the jury a little bit more about that?
Yeah, she's always checking in on her firefighters. For starters, she took shifts for me when I needed it, and also for other firefighters.
You said for starters. Is there more that Ms. Sutcliffe does?
For example, Dakota once personally escorted an elderly woman to the hospital after she had inhaled too much smoke. That's not in our job description, but that's the way Dakota always operated.
Now, was Ms. Sutcliffe working on August 1st with you?
Yes, she was. It was awful to see her lose her bar and her fellow firefighter in the same day.
Now, I'd like you to walk us through your unit's response to the fire at Chuggy's. How did you initially approach the scene?
We initially approached the scene by determining if we should take out the fire externally or internally. Basically, if we should fight the fire from the outside or the inside. When we pulled up and we saw how heavy the smoke was, we decided to fight the fire from the inside.
And what happened after you decided to fight the fire internally?
Well, we went to the back entrance of Chuggy's and felt the door for heat. We didn't see any flames on the outside, but in my experience, a hot door usually means that there are flames on the inside. So Jalen broke down the door while I established ventilation.
Why did you establish ventilation at Chuggy's?
Because Chuggy's is a dive bar, meaning there are no windows and no airflow.
And what did you and Jalen do after establishing a point of entry?
After we established a point of entry, we went inside to sweep the ground floor. The inside was just an inferno, but it was mainly concentrated towards the kitchen area.
What did you do after realizing that the fire was mainly concentrated in the kitchen?
After we swept the ground floor, we decided that we should go downstairs and check the office and storage area.
Why were you checking the office and the storage area?
Well, we were informed that Chuggy's had closed earlier that night due to a problem with COVID, so we thought that employees still might be there, and the most likely place that they would be in was the office or the storage area in the basement.
Miss Silva, did you find any people inside Chuggy's?
Thankfully, no, so we raced back upstairs as fast as we could.
Did you have a plan for once you got back upstairs?
Well, when we got to the stairs, just everything started to go wrong.
How did things start to go wrong?
When we got to the top of the stairs, I looked at Jalen and pointed to the right so we could check the bathrooms in the hallway. Jalen gave me a thumbs up, so I turned around and ran for the bathrooms.
What happened after you ran to the bathrooms?
I heard an awful cracking sound and a crash, and that was it.
What was it, Miss Silva?
I turned around and Jalen was gone. He wasn't behind me.
Did you find out where Jalen was?
I saw that the ceiling had fell and part of it had fell on top of Jalen.
How did she know that?
I saw his helmet among the debris.
Did you and your unit try to save Jalen?
We wanted to. I mean, we really did want to, but it just kept getting hotter and hotter, so we had to just run through the door.
What happened after you got outside of Chubby's?
I turned around and the complete building just had fell in on itself and it was engulfed in flames.
I'm sorry for your loss, Miss Silva. I know that must be hard. Let's pivot a little bit back to Miss Sutcliffe. Are you aware that she is being accused of starting that fire?
Yes, I am.
Do you have any reason to believe those accusations?
No, I don't have a single reason to
Objection.
believe that.
Relevance?
Response, Your Honor?
Go ahead.
Ms. Silva just testified that she worked with Ms. Sutcliffe for 4 years as a firefighter, meaning that they've had many conversations. She knows her personality. She just testified to how good of a person she is. If she did have any reasons why Ms. Sutcliffe would have started the fire, it's extremely relevant and it's extremely important for the jury to know those reasons or to know that she didn't have any.
May I respond?
Go ahead.
Your Honor, whether or not Ms. Silva believes that the defendant caused this fire, that does not make any fact in today's case more or less likely. It's up to the jury to decide based on the evidence and testimony today, not for Ms. Silva.
Brief response, Your Honor.
Go ahead.
As you know, in Midlands, the bar for relevance is extremely low, and my question to Ms. Silva was not if she believed that Ms. Sutcliffe started the fire, it was if she had any reason to. Those are very different questions. If she had reasons to, those would be based on her years of experience knowing Ms. Sutcliffe, and so that is relevant for the jury to understand all the facts of this case and for them to come to their conclusions.
Overruled.
Ms. Silva, I'll ask one more time. Do you have any reason to believe the accusations against Ms. Sutcliffe that she started the fire at her own bar?
No, I have no reason to believe that Dakota would start a fire. She fights the whiskey, so she knows how dangerous they can be and how they can hurt people. And Jalen was just as much as a friend to me
Ms. Silva. Your Honor, I have no further questions at this time. Cross.
Yep, witness is reviewed.
Good evening, Ms. Silva. Good evening. You're pretty close with the defendant, right?
Yes, we work together, so I would say we're friends.
And there were times where she spoke to you about Chucky's bar.
Yes,
She told you about the renovations she was planning.
yes,
And you heard about how those renovations were delayed.
yes, she would talk about it at her.
She complained that she couldn't open Chucky's for New Year's Eve.
Yes, I know it really affected her because she was really looking forward to having the New Year's party and even invited her coworkers at the fire department.
She couldn't open for that day to have that New Year's Eve party.
No.
The defendant also complained to you that the material costs for those renovations were really expensive.
She would complain about things that were going on with the renovations. Yes.
She complained that those construction delays only added to those costs.
I never really asked specifically about money issues just because it wasn't really my business.
But she did complain to you multiple times how expensive those renovations were.
Yes.
Now, I want to talk to you about the night of the fire. You were at the fire station that night, right?
Yes, it was.
You were there when the alarms went off. At that very moment, the defendant came rushing in.
Yes, she did. I know sometimes she would like to hang out in the back room. Everyone was just rushing to get to the fire room.
Just to be clear, that was the first time you saw her that night.
Yes.
She was supposed to be on shift several hours ago.
Yes, she was. But like I said, sometimes she hung out in the back room, so I wouldn't have seen her.
And so the first time you saw her that night was right when the alarms went off.
Yes.
Now, when you got to Chucky's, you and Jalen went into that building.
Yes, I did.
And when you were upstairs, there was a crash.
Yes.
That's when Jalen was killed.
Yes.
He was killed in that fire.
Yes, it was.
That's when the defendant told you, this can't be happening. It was all planned out.
Yes, and I agreed because the 2 and 2 out policy was just supposed to always be reliable and keep us all safe, and Jalen should have never died.
Just to be clear, you don't know what plan the defendant was talking about.
No, but I would assume that's what she was talking about because it was just such a traumatic event seeing Jalen's helmet next to the debris.
So, I'm not asking you to assume. You don't know what plan the defendant was referring to.
No, I don't.
And I want to briefly talk to you about your job as a firefighter. You've been a firefighter for 8 years.
Yes, coming on that, yeah.
And you used to work at the Midland Center Fire Department.
Yes.
Now, through that job, you learned the damage that fire can cause.
Yes, I did.
You also learned the danger that it poses.
Yes.
The defendant was a firefighter at the same fire station.
Yes, she was.
Thank you. I have no further questions at this time.
Any redirect?
No, Your Honor, not at this time. I just asked that Ms. Silva be able to step down.
You're excused. Go ahead, Janice.
Your Honor, we call witness Toby Johnson, please. Please introduce yourself to the court.
Hey, what's up? I'm Tobin Johnson.
What do you do for a living?
Currently, I'm working in retail, but I used to work at Chuggy's, a local bar. Excuse me.
How is it working at Chuggy's?
It was great. I love the environment of a bar, hanging out with regulars.
Who was your boss while working at Chuggy's?
Well, for the first year and a half, it was a guy by the name of Jordan James, but then he sold the place to Dakota in the summer of 2019.
Now, what was it like working for Jordan James?
It was pretty good. It was all right. Maybe it was laid back. Jordan was the kind of guy that didn't really care how things got done. A lot of messes, a lot of underage kids. But that all changed under new management.
Now, you mentioned Dakota Sutcliffe. How was your working relationship with her?
It was great. Dakota, I liked a lot. She was always willing to help out with whatever we needed around the bar. And she's a volunteer firefighter, so I respected her for that.
Now, aside from your working relationship with Dakota Sutcliffe, what was it like working for her in general?
It was higher maintenance, more bar prep, more cleaning, just overall more responsibility, but it made the bar a lot better place, so I appreciated it.
And how was business under Dakota Sutcliffe's management?
Back in October, it was great. I mean, we had a lot of people. We had a huge Halloween party. That party got so full that we couldn't even let people in after that. I just started to point that is.
Why couldn't you let any more people in?
Well, we were enforcing the bar's max capacity. Dakota was pretty serious about that.
Was Dakota always serious about enforcing max capacity rules?
Yeah. Dakota was pretty serious about enforcing a lot of rules. Like I said, she was a cleaner. She also was pretty serious about underage kids. She wouldn't mess around with things like that. I could think of an incident.
Could you tell me about that?
Yeah, back in November 2019, there was a regular, Kieran Singh, who would come to the bar. And then that night, I went to the front of the bar and I saw Kieran getting into a little bit of a scuffle with Dakota, and, just because Dakota had taken Kieran's ID.
And why did Dakota take Karen's ID?
Well, Kieran was underage and the ID was fake.
And did any other instances like this happen in the future?
No. Shortly after that, we closed up for renovations.
What kind of renovations?
Well, we were redoing the bar, adding a new basement for seating area, another bar, and also adding a back patio for bands.
And when did these renovations begin?
They started after Thanksgiving, so around December of 2019.
How was it working at Chuggy's during these renovations?
It was easy. It was all I could ask for. Dakota paid us during that time, which was nice, so I decided to chip in with the renovations when I could.
When were the renovations finished?
They were finished on January 5th. Well, everything except for the back patio.
And how is business post-renovations, Mr. Johnson?
It was pretty good. I feel like it could have been a little bit better, but I figured it would get better coming out of winter.
And did business get better?
A little bit. We had to pick up in business, but then COVID hit, so we closed up.
And how did COVID-19 affect your employment at Chuggy's?
Well, we had to switch from inside service to takeout and delivery, so I became our delivery guy.
How long did you do takeout and delivery for exactly?
Until about the end of May.
And how was business during that time period?
It was starting to pick up then. We were actually looking to do a lot, but COVID became more of an issue again.
And how did COVID become more of an issue?
Well, our cook actually tested positive on July 15th.
Now, Mr. Johnson, I'd like to talk with you a little bit about the day of July 31st. You were working a shift at Chuggy's that day, correct?
Yeah, that's right.
And did anything out of the ordinary happen during your shift at Chuggy's?
Yeah, actually we got a shipment from Harlow's that I didn't know was coming.
Is it unordinary to get shipments from Harlow's?
No. This one was just a little weird because it was paint thinner, and at that point, I thought we didn't need it anymore.
And did you find out what the shipment was for?
Yeah, well, like I said, we were still working on the back patio, and that paint thinner was to finish the back patio.
And Mr. Johnson, did you see this paint thinner anywhere else in Chuggy's that day?
Yes, I saw Dakota move it around like 6 when I was going out for deliveries. She took it down to the basement.
Where at in the basement exactly?
It was underneath an electrical box in the basement.
Now, Mr. Johnson, if I showed you a diagram of Chuggy's today, would you recognize it?
Yeah, sure.
Your Honor, permission to approach opposing counsel with what has been pre-marked and pre-admitted as Exhibit 3 under Stipulation 11.
You may.
like a courtesy copy?
Yes, please.
Approaching the witness with the same. What have I just shown you, Mr. Johnson?
And it's basically just like a map of Chuggies.
And is it a fair and accurate copy?
Yeah, I would say so.
Mr. Johnson, would a demonstrative aid in your testimony today?
Yeah.
Your Honor, permission for the witness to exit the stand in order to make use of the demonstrative aid?
Granted. Go ahead.
Thank you.
Now, Mr. Johnson, could you please point out the location of the electrical box in the basement on this diagram of Chuggies?
Yeah, so the right side here is the basement. And the electrical box was here, next to the dartboard. And the box that Dakota moved was directly under that electrical box right there.
Thank you, Mr. Johnson. Permission for the witness to return to the stand.
Go ahead.
Thank you.
Now, are you aware that Dakota Sutcliffe is here today being accused of setting the fire at Chuggies?
Yes, I know.
And Mr. Johnson, do you have any reason at all to believe that Dakota Sutcliffe would do such a thing?
No, no shot. I mean, Dakota put more money, time, and effort into that place than I'd seen anybody else.
Objection, Your Honor, speculation. Would you like me to explain? Your Honor, the witness, in order for the witness to answer this question, they would have to enter the mindset of the defendant to know if they had wanted to set fire to Chuggies.
Response, Your Honor. Go ahead. Your Honor, this is not speculation. This is only based on the witness's own rational perception of events. Mr. Johnson worked with Dakota and knew Dakota very well. They would even consider each other friends. Therefore, Mr. Johnson could speak to whether or not he thinks Dakota would commit such an act of arson.
It is not within this witness's rationally based perception to know what the defendant would be thinking and if they would want to or wouldn't set fire to Chuggies. They would have to enter the defendant's mindset in order to have that knowledge. And that's what calls for speculation in this question.
Response, Your Honor.
Go ahead.
The witness is not entering Dakota Sutcliffe's mindset. The witness is only speaking to his rational perception of Dakota and of working with Dakota and knowing Dakota personally and whether or not he thinks if Dakota would have done such a thing as commit arson.
Last response, Your Honor.
Go ahead.
Just because the witness knows the defendant, that doesn't mean that he knows every decision that the defendant would ever make. In order to be able to know what decision the defendant would make in this specific situation, he would have to enter her mindset, and that means it calls for speculation.
One more brief response.
Final response.
The witness is not testifying to the decision that Dakota Sutcliffe would make. The witness is only giving his own rationally based opinion on whether he believes Dakota Sutcliffe, after knowing her personally, would commit an act of arson. He is not trying to tell the jury what Dakota's thought process was or what Dakota's ultimate decision was and why Dakota made that decision. He's only saying what he thinks in terms of today's case.
Overruled, but keep the scope of your question only to his knowledge.
Of course, Your Honor. Now, Mr. Johnson, let me ask you that question again. Do you have any reason at all to believe that Dakota Sutcliffe would commit such an act?
No, no shot. I mean, considering having known Dakota for as long as I did and knowing how much she loved and how much time she put into Chuggies, she would never do such a thing. I mean, just from what we did, if we'd given just a little bit more time, we could have had a bar that would have been a mainstay in Midlands for a long time. I mean, you just don't burn down something that you put so much time and effort into.
Thank you. No further questions, Your Honor.
The witness is with you. Please.
Cross-examination, Your Honor.
Go ahead.
Mr. Johnson, I just have a few more questions for you. So in November, like you said, the defendant was planning on doing some renovations to Chuggies.
Yeah.
They took out a $1 million loan to do those renovations.
Yeah, I mean, when we saw what she did with the money, it was pretty impressive. The bar looked fantastic.
She spent a whole month for those renovations.
Yeah, I mean, it took a little bit more than a month, but it ended up looking great.
She closed down Chuggies for all of December.
Yeah, we figured that was the best time because all the college students were going. It was a slower part of the year.
she intended for Chuggy's to reopen by New Year's Eve.
Yes.
New Year's is one of Chuggy's most profitable nights.
Yeah, I mean, considering people like to go out on New Year's.
But like you said, the renovations took a little bit longer than expected.
Yeah. Working with contractors is always tenuous, but that's why. There were delays with them.
Chuggy's wouldn't reopen until January.
Yeah, we ended up opening on January 5th.
You heard a phone call that the defendant was talking on, where she sounded concerned about missing New Year's at Chuggy's.
I don't know what instance you're referring to. I mean, I've overheard a few phone calls that could have been Dakota, but I'm not sure what you're talking about.
Well, on this phone call, the defendant was worried about being unable to cover some loans without that New Year's Eve money.
I'm not entirely sure if it was related to New Year's Eve, but I did overhear a voice say something about loan payments, yes.
Now, like you said, a lot of renovations took place at Chuggy's.
Yeah, I mean, we totally added a new basement area, and just totally changed the overall look. I mean, we brought everything back to the studs, so it was brand new.
Right, one of those things that really needed to be changed was the electrical equipment at Chuggy's.
Yeah, we were, we had guys rewire all of it. Sometimes when we'd have bands play, the lights would flicker, stuff like that.
Right. Electrical wiring could spark if it's, not new and improved, correct?
I'm not entirely sure, but
Objection, Your Honor, improper lay opinion. This question, Tobin Johnson is not an electrician. He cannot speak to the electrical specifications of the electrical box, and therefore this question is asking him to attest to something that he does not know enough about.
Response, Your Honor? Well, for starters, I'm not talking about the electrical box specifically. I'm talking about electrical wiring as a general. And you don't need to be an expert to know that if electrical equipment is outdated, it could potentially cause a spark.
However, this question is still asking Mr. Johnson to talk about the state of the electrical box at Chuggy's and also talk about whether or not that state could have potentially caused a fire if there was to potentially be a spark. Therefore, this testimony is out of the scope of Mr. Johnson's lay opinion.
Final response, Your Honor. I'm simply asking the witness to, within his own knowledge, to say whether outdated electrical wiring could potentially create a spark. I'm not asking him to say whether that spark could create a fire, whether that spark created a fire at Chuggy's. I'm just asking him a general question that he can simply answer yes or no to.
Sustained, rephrase the question.
Like you said on direct examination, lots of those renovations took place in the basement.
yes, that's right.
One of those renovations was the renewing of the electrical box in the basement.
Yes.
So it was a brand new electrical box at the time of the fire.
Yes.
Now, I want to talk a little bit about after those renovations took place. Business never really picked up like you had hoped it would.
Following the renovations, no, but I figured that was concerning, just like the winter and the ice. There was an ice storm as well.
Tips were down.
I mean, overall, customers were down. I mean, customers in person were down. So yes, tips were down.
And COVID closed down Chuggy's altogether.
Yeah, for a period of time.
Come May, the defendant even told you that she wouldn't be able to pay you for at least a few months.
She mentioned that we would have to go without pay for a little while, but I was willing to do it because I just care about Chuggy's that much.
She was having to beg the bank for more time and more money to keep Chuggy's running.
I'm not entirely sure that she did that. She did mention asking the bank for help once, but I'm not entirely sure now.
Well, she told you that she was begging the bank for more time to keep Chuggy's running.
She mentioned that she asked the bank for an extension, but I don't know about begging. I mean, it's possible.
She was running out of options.
mean, I guess you could say that. I'm not.
Objection, Your Honor. This question calls for speculation. By asking the witness if the defendant was running out of options, it causes the witness to have to look into the defendant's head and look at her mindset and what her specific situation is like, which he cannot testify to.
Response. It is within this witness's rationally based perception to know whether or not his boss, his main employer, was losing time and losing money. Those are simply the questions that I prefaced the no options with. And based on his rationally based perception, he would know if the defendant was running out of options to keep Chuggies running. And as he just said, the defendant was already asking the bank for more time and more money, so she was running out of options.
Response, Your Honor. Go ahead. Just because the defendant was potentially running out of time or money does not mean that Mr. Johnson can look into her mind and magically see if she was running out of options or didn't know what to do. Mr. Johnson doesn't know what Ms. Dakota was thinking at the time and therefore cannot properly answer this question.
Your Honor, if allowed to continue with questioning, I can lay the foundation for how this witness would know that the defendant would be running out of options and felt that way, and made that clear to the witness.
Sustain with the foundation first.
The defendant told you that she was even thinking about selling Chuggies,
Yeah, she did tell me that.
the place that she loved most.
Yeah, I would say this is the place that she loved most. I mean, we both did.
The place that she had just spent an immense amount of time and money into renovating.
Yeah, we definitely spent a lot of time and money on that.
A place that she had spent an immense amount of time building up,
Yeah, exactly.
just for it to become a bigger burden on her financially.
I mean, all investments are at one point a burden, but I mean, I guess you can say that.
In July, and the defendant again told you that she was thinking about selling Chuggies.
I believe we only spoke about it one time.
That the defendant did tell you, like you had already answered, that she had been thinking about selling Chuggies.
Yeah, that's right.
2 days later, Chuggies caught fire.
I don't know if they were within 2 days of each other, but it did catch on fire later on.
Thank you, Mr. Johnson. I have no further questions at this time.
Any redirect? No redirect, Your Honor.
Thank you.
Your Honor, at this time, the defense rests its case in chief and time pending, of course, ask for a brief 5 to 10 minute recess before proceeding into closing arguments.
Go ahead, if time permits, we can go ahead and take a 5-minute break.
Judge, copy the stipulations.
Yes.
Are all relevant parties back? The prosecution is here, Your Honor.
Defense is here, Your Honor.
All right. The prosecution may go ahead with their closing statements.
Your Honor, opposing counsel, members of the jury, may it please the court. Nothing to lose. On the night of July 31st, last year, a team of firefighters from Midlands Fire and Rescue was dispatched to downtown Midland Center. Why? Because a local bar called Chuggy's was being swallowed by fire. 4 firefighters went into the building that night, but only one person knew where that fire was before it even started. Only one person hoped that that bar would burn to the ground. Only one person had nothing to lose and everything to gain. That person was not only the owner of Chuggy's Bar, they were a volunteer firefighter. Her name is Dakota Sutcliffe, the defendant in today's case. We're here today because the fire at Chuggy's wasn't an accident, members of the jury. It was intentionally set, an act of arson. Before we get into why the defendant would do that, I want to talk and be very clear about how we're going to come to our verdict. To make it simple, we've broken down that verdict into 2 easy questions the prosecution had to answer in today's case. 1, did Dakota Sutcliffe knowingly create a fire at Chuggy's Bar? And 2, was that fire dangerous enough to harm or injure someone? We had to prove those things to you beyond a reasonable doubt. A doubt based on reason. That doesn't mean any and all doubt. It doesn't mean potential doubts. It only means doubts based exclusively on logic and reason. To believe and prove that the defendant is guilty in today's case, you have to believe that the prosecution's argument is the most reasonable one. So let's take those questions one at a time. 1, did Dakota Sutcliffe knowingly create a fire at Chuggy's Bar? Well, that question might have been hard to answer at the beginning of today's trial, but members of the jury, it is very clear now. You heard from Alex Silva, a firefighter who was there that night fighting the fire at Chuggy's. She told you she saw the defendant walk in through the front door and somehow know exactly where the fire was before anybody else did. Members of the jury, when they finally got to the scene of the fire, the defendant said,
I can't believe this is happening. I had it all planned out. The question is, why did the defendant have a plan? What was it? And we brought financial investigator Nora Khan to help us better answer that question. Ms. Khan told you very clearly that the defendant kept lapsing on multiple loan payments after she took out a $1 million loan. Out of options, unable to pay back the loans, with nothing left to lose, the defendant desperately started searching for options. And she found something to the tune of $1.5 million, a fire insurance policy. Being a firefighter, the defendant knew all the ins and outs of how fire occurs, how the evidence is taken, and exactly what happens after the investigation. She was inside on the job. If her plan worked, she would walk away with $1.5 million. Well, members of the jury, it was a good plan. But what the defendant didn't plan for was Miss DeJong seeing her that night at Chubby's bar, walk right away from where the fire occurred all the way to the fire station. Members of the jury, it is very clear that Dakota Sutcliffe had a problem, and she planned to get rid of it by burning down her own bar and getting a payout of $1.5 million. Now, we aren't saying that Dakota Sutcliffe is an evil mastermind, but members of the jury, when we're in hard situations and in extreme concerns, we turn to very extreme measures. With nothing left to lose, she did what she had to. She cut her losses and made that plan. So did Dakota Sutcliffe knowingly create a fire at Chubby's bar? The answer is yes. And that brings us to our second question. Was that fire dangerous enough to injure or kill someone? Well, members of the jury, take a look for yourself. These are pictures of Chubby's bar after the fire. Destroyed beyond repair, reduced nearly to rubble. And we brought in the person who examined that rubble for you today, a federal arson investigation specialist, Detective Weber. And he told you three very important things. He explained that he analyzed the scene, that the origin of the fire was the kitchen. He also told you that there was paint thinner found spread throughout that area, a fire accelerant, and he ruled out all the other alternative possibilities. Now, the defense tried to hire their own expert, Ms. Syed. They paid her a fee, and they tried to make her tell you that the detective was wrong. But even Mrs. Syed, on cross-examination, had to concede that all she had was opinions. She didn't run any tests, she didn't speak to any witnesses, she didn't collect a single piece of evidence. And members of the jury, if you're still not convinced as to how dangerous that fire really was, look back to what Mrs. Silva told you today. She said that that night, she didn't just lose Chubby's bar, she lost her colleague, Jalen Williams. It's very easy to lose sight of what this trial is really about. And that's not just a financial motive, members of the jury. Somebody lost their life in today's case. Dakota Sutcliffe had a debt, and Jalen Williams paid that debt with his life. When looking back on today's case, remember a very, very important question. When the defense tries to come up here and cast doubt on the prosecution, you have to ask yourselves, are those doubts reasonable? Ask yourselves, who had the means, the motive, and the opportunity to commit this crime? There's only one person who had the means, only one person who had the motive, and only one person who had the opportunity. And the answer to all of those questions, members of the jury, is the defendant in today's case, Dakota Sutcliffe. As the trier of fact, you came today to trial and took an oath yourselves. You promised to come to a fair and just verdict based on the evidence presented in today's trial. After a certain point, members of the jury, coincidence after coincidence stop being coincidences and start becoming evidence. The evidence in today's trial is very clear. Find Dakota Sutcliffe guilty of aggravated arson.
May I prepare the law, Your Honor? May I proceed?
Go ahead.
May it please the court, Mr. Chitintakayala, members of the jury, you don't burn down what you build up. That is why we are gathered here in court today. Because a local resident, a local business owner, and a local volunteer firefighter has been wrongly accused by the state of burning down her own business. That business is Chuggy's Bar. Hopefully you've had a chance to hear about it today. You heard about the owner before Ms. Sutcliffe, how there was a disregard for the rules and there was little to no investment in time, energy, or resources into building up the bar and making it better. But that all changed with Ms. Sutcliffe. You heard from coworkers. She took out a hefty bank loan, that she invested that into her business, and she wanted to build it into something better. Everyone around the defendant knew that she loved that bar, and they knew she would not burn it down. Ladies and gentlemen, it's safe to say that the events on July 31st and August 1st of 2020 are undoubtedly tragic. Perhaps some of the worst hours in Ms. Sutcliffe's life, chiefly because she lost a friend, Mr. Jalen Williams. Mr. Williams is one of the firefighters that bravely stormed into Chuggy's that night, and he didn't make it out alive. Ms. Sutcliffe worked with Mr. Williams. Now, despite the tragedy at the heart of today's case, keep in mind, members of the jury, that Ms. Sutcliffe entered this courtroom today cloaked in innocence. She entered this courtroom cloaked in innocence because, members of the jury, you have no assumption in today's trial that Ms. Sutcliffe had nothing to lose. You have no assumption in today's trial that she would be willing to burn down everything she built up. Under the Midlands Penal Code, Section 18-403, arson is defined when someone knowingly creates a substantial risk to a person or property with the purposes to defraud. Now, look no further than the state's own forensic investigator, Ms. Noor Khan, to see that the state did not meet that burden under the law. That burden is beyond a reasonable doubt, and it's the highest burden in our legal system. Ms. Khan analyzed the witness's bank statements, insurance records, and she told you multiple times on the witness stand today that she found no indication of fraud. She also told you that a significant part of that loan agreement was that if arson was suspected, well, the defendant wouldn't get a dime, and the defendant has gained nothing from that insurance policy to this day. Now, in all of your heads, you're wondering, how was this potential crime committed? Well, there are two experts called in today's trial. You heard from one with limited time, resources, and capacity to make an informed decision, and you heard from another who used that investigator's facts and more to come to her conclusion. Mr. Weber told you the longer a fire burns, the harder it is to pinpoint the origin of that fire. Mr. Weber told you the longer a fire burns, the harder it is to pinpoint a cause to that fire. Mr. Weber also told you that over an hour and a half passed before he was able to enter Chuggy's. And Ms. Saeed told you at the point at which Mr. Weber entered Chuggy's, well, the crime scene had already been significantly tampered with. Chuggy's collapsed that night due to the fire. And Mr. Weber can't tell you what is in its original position, what was moved by first responders, or what was in certain places of the business because of renovations that night. In fact, Ms. Saeed told you unequivocally that the facts that renovations were occurring that night tell you that this could be a non-arson case, and that paint thinner was not used as an accelerant for that fire. You heard from observers of that day. You heard from Skylar DeJong, who used to work alongside Miss Sutcliffe. She told you that Miss Sutcliffe followed the rules. You heard from Mr. Tobin Johnson, who worked alongside Miss Sutcliffe. Mr. Johnson affirms the same thing, and Mr. Johnson told you that contrary to what Mr. Weber believes, all the paint thinner that he saw in Chuggy's the night of the fire was nowhere to be found in the kitchen area on the first floor of the structure. It was all in the basement by the donuts. Ladies and gentlemen, Mr. Weber did not say that the fire started in the basement. He said it started on the first level. Meanwhile, the state called no witness, indicating that any paint thinner was seen on that first level. You also heard in today's case from Miss Alex Silva. What Miss Silva told you was that Miss Sutcliffe knows the dangers of fire and that it can potentially take a human life. What Miss Silva told you in today's case is that Miss Sutcliffe would have never committed this act of arson. Ladies and gentlemen, the defense in today's case wants you to remember a number. That number is 0. Not a single witness in today's trial can say that they saw Miss Sutcliffe start the fire at Chuggy's. Not a single witness in today's trial told you that they saw Miss Sutcliffe purchase paint thinner. Not a single witness in today's trial told you that Miss Sutcliffe started a fire and used paint thinner to engulf the entirety of Chuggy's. Ladies and gentlemen, that's reasonable doubt. And that's the burden that the state has not met under the Midlands Penal Code. And that, for you, the decision makers in today's case, is a not guilty verdict. If you find any reason to believe that Miss Sutcliffe would not have burned down what she built up, you must acquit her. If you find any reason to believe that the paint thinner found in Chuggy's was because of the ongoing renovations instead of used as an accelerant, you must acquit her. If you find any reason to believe that Miss Sutcliffe had everything to lose, you must acquit her. As you go into deliberation, we urge you to look at the facts and to look at them closely. You'll have the defendant's financial records and insurance documents. You'll have the testimonial witnesses, the testimonial evidence from all the witnesses you heard from in today's trial. But most importantly, you'll have the character of the defendant on the line. She lost a friend that day, and Midlands lost a resident. The defense doesn't take that lightly, but at the same time, the defense recognizes that Miss Sutcliffe has been wrongly accused and that you don't burn down what you build up. Find Dakota Sutcliffe not guilty of aggravated arson. Thank you.
Rebuttal, Your Honor. Members of the jury, the defense just came up here, and they tried to tell you that nobody saw Miss Sutcliffe set that bar on fire. Remember the key word in today's verdict: reason. If somebody saw Miss Sutcliffe setting this bar on fire, we wouldn't be in trial today. It's that simple, members of the jury. So let's go over the evidence that we know, we have, and that we've reviewed throughout today's trial. Let's first look at the science. We brought you a federal arson investigator who told you. He analyzed the scene. He found fire accelerant, and he ruled out every other alternative possibility. He ran tests, he collected physical evidence, and he gave you hard facts. We also brought you a financial investigator who told you about the motive in today's case. Miss Sutcliffe had nothing left to lose. She couldn't pay back her payments, and all she had left was this last-ditch effort, a fire insurance policy. And lastly, we brought you a witness, Ms. DeJong, who saw the defendant at her bar that night, right before it was set on fire. and walked to the fire station. Members of the jury, if you still aren't convinced, you heard Detective Weber tell you that just days before the fire, the defendant purchased gallons of paint thinner from the hardware store. And even Miss Sy told you herself she believes it's highly unlikely that paint thinner was in use in that kitchen before the fire. That means it was there with the purpose of intentionally lighting Chuggies on fire, to get the payout because she had nothing left to lose. Members of the jury, justice is essential. Find Dakota Sutcliffe guilty for aggravated arson. Thank you.
Right, judges should please complete their ballots, furnish, check if they are completed, and then we will do some brief comments. Good job, everyone.
Superrunner, do you possibly have a blank ballot?
I'm sorry.
Do you have an extra blank ballot?
Yes, I do. Do you not have one?
I have one. I just made a mess of it.
Okay, no worries. I can